ADA final rule, Title II, was published April 24th, 2024. Final rules that are published federally have 60 days to take effect. That means that the rule took effect on June 24th, 2024. My birthday, thank you. What does that rule do? That rule sets WCAG, or Web Content Accessibility Guidelines, 2.1 level AA as the standard. Now, I will say, until this rule was published, we did not actually have a hard and fast definition of what digital accessibility meant. We had an inkling. We had pointers. The best kind of rule that we had was like, maybe you got OCR to say something, but I guarantee you they did not put it on the record. And our best guess was what judges were saying in lawsuits. And judges were having to talk to digital accessibility experts and find out like what standards should I hold these people to, because the feds aren't saying what it should be. Now they're saying what it should be. However, judges were pointing at WCAG 2.0 level AA compliance. Okay, so the new rule did tweak that a little bit. Hopefully we were kind of prepared for that, but that is the standard. And that is the standard, depending on your organization size, that you will be held to starting June 2026 or June 2027. So if your agency, organization, district has a population, not a student population, not an FTE, not anything else. If you have a border that you serve, how many people live within that border? Okay, residents. If you have more than 50,000, the feds assume that you have some resources available to you, and you will be held to this standard starting June 2026. If you have less than 50,000, or if you're an agency that does not have a defined border in a population, you will be held to that standard starting June 2027, right? It's either 2 or 3 years from the published, not the published date, but the rule going into effect date. So June 2026 or 2027. For example, in Muskegon County, no school district on its own has a population of more than 50,000. However, the ISD, of course, serves all of those, and we do. So in Muskegon County, the ISD will be held to the standards starting 2026, and our constituent school districts would be held to it in 2027. Any questions about that? Okay. So who's affected? We work in public service, pretty much everyone we talked about. So state and local governments, contractors of state and local governments that provide public services for them. That includes your district or organization is responsible for the content, even if literally your staff don't create it, but you contract someone else to create it for you. You're both held to that standard. State and local governments who provide public services, social services, food assistance, health insurance. Michigan Works, all those places. Public schools, community college, public universities. State and local police, courts, elections, hospitals, clinics, parks and rec programs, libraries, transit agencies. All of these places are covered under Title II. Notice that private companies are not in that list. That's because they are not covered by Title II. They're covered by a different title. This rule is specific to Title II. However, if you're working with an agency or a company or something like that, that is not on this list, but you're working with them for the benefit of your constituents, it probably needs to be accessible, whatever you do, if it's digital. So like I said, prior to this update, we were looking at WCAG 2.0 level AA standard. We often ignored third-party content. There was debate about this. Karen's nodding because she was in on the debate for a long time about third-party content. Muskegon was pretty strict about the fact that third-party content we thought was included because it was part of our services. And other organizations just went like this and went, no, no, we're not worrying about that. That's third party. Nope. OCR won't literally tell me that that's a problem, then we're not gonna go there. And until now, enforcement was focused on our public facing websites because that's what we got complaints about. However, this rule makes no distinction between your website and anything else you do digitally. It's all one and the same to them. So the rule has a number of exceptions within it. I'm going to go over literally all of them because they're important. So what is not covered under the rule starting June 2026 or 2027? Number one, archived content. Things that were created before the deadline, not before now, not before June or April this year, before that deadline in the end. If it's not for active use and you do not use it for a new purpose or update it. So if you have the library of board meeting minutes for every month back to the beginning of time, those won't matter. Except, there's always an exception to the exception, right? If you're posting those, and hopefully they should be under like an archived section of your website, right? Those are fine. They can stay there. You don't have to make them accessible. Until or unless someone reaches out and says, hey, I want to access this and I can't see it. In the end, no matter what exception you have, if someone requests access to something, you need to accommodate them. We know all about accommodations. We accommodate people all the time. Even if it's listed under an exception and someone needs it, and they say they want it, you need to give it to them in a way that they can perceive. So keep that in the back of your mind for all of these exceptions. So archived pre-existing documents, one and the same. If it was made before this deadline, you do not have to technically worry about it for this rule. Keep in mind, we have all been covered under ADA and Section 5 before this entire time. So if someone needed something and asked for it accessibly, you should have been providing it anyway this entire time. This should not change that much. Okay? There is an exception for third-party content. Don't get too excited. Okay? That exception only exists for a couple of scenarios. Whatever it is cannot be posted there for a contractual, licensing, legal, some other arrangement. If you are required to put it there, it doesn't matter that it's third-party content. It needs to be accessible. Number two, if it was created for the agency, if you are considering this within your realm of official content, you're using this officially in your capacity as an organization, it needs to be accessible. It doesn't matter that someone on your staff didn't create it. Okay? And that's when we're thinking about curriculum guides and, you know, Common Core standards and whatever else you're linking to and using. It needs to be accessible. Okay, here's the next exception you might get excited about. Individualized documents protected by a password. Shh, don't hang on that word password too tightly, okay? I know it's exciting to hear that, but no. Just because something is behind a password does not mean you don't have to make it accessible, okay? This exception is very specific that it only applies to documents, not web-based or HTML-based content. So it also depends on whether that is the only way for me to get that information or not. So my example is, obviously, I'm on the PowerSchool support team, PowerSchool parent portal. Parent can log in and see all their stuff, right? That's all web-based information. But maybe you have the document delivery add-on, and so you have an archive of report cards on there. I'll tell you right now, the reports that PowerSchool generates, the PDFs, oh boy, I need to plug in. Not great for accessibility. I have kind of beef with PowerSchool over that, but hopefully they improve. However, if you use PowerSchool, the new advanced reporting, if you haven't heard of it, because of course they're charging more for it, does produce accessible documents very happily, actually. So that might become a thing in your budget within the next year or two. And we're talking about it in Muskegon. So we're safe. Okay. Obviously, to get to that parent portal, that parent has to have a password, right? It says right here, individualized documents protected by password don't have to be accessible. That's great. If I can log into the portal and I can pull up a report card, technically, that doesn't need to be accessible. If I can get all the same information from that report card on the web page. But if it's the only way for me to get that information, it should be accessible. Does that make sense? The password doesn't like shield you from that possibility of a complaint. Another exception, pre-existing social media posts. Yes, they're actually coming out and saying, yes, social media posts are included in accessibility requirements. They are an official communication tool from your district. So the things that you're posting should be accessible. The only thing that doesn't have to be accessible is old posts from before this deadline, according to ADA Title II. Remember, we've been covered by ADA and Section 504 this whole time. So don't wait 2 or 3 years to actually come around to this. But they are saying that social media posts going forward should be accessible. Now I get that social media, there are only so many tools you have available on Facebook and Instagram and Pinterest and all the other places, right? Use those tools, right? Put alt text on your stuff. Put image description in the post itself if you have to. Make sure your links make sense. They're not just bit.ly/AX4GY whatever, right? You can customize that. You can make it make sense and point to something. You're going to point at a PDF or a website, make sure wherever you're sending them is accessible, right? Caveat though, if you're just sharing information from another community organization and it's not official content, same exception applies. That's not really your programming. You don't have to worry about that, okay? I mentioned this already, the exception to the exception. If someone with a disability requests information that is even covered by an exception, it must be made accessible, provided with effective communication, reasonable modifications, and an equal opportunity to participate in or benefit from your services. That's literally from the law. If you pull up the slides later and click on those, it'll take you to a definition of those things and give you more information.